Vallow Daybell is back in court Monday for opening statements in her murder conspiracy trial in Arizona. Vallow Daybell is accused of conspiring with her brother to kill her former husband, Charles Vallow.
Now, she pleaded not guilty and is representing herself. Monday, she denied accusations that her husband's murder was a ploy to gain insurance money and also claimed her brother killed Vallow in self-defense.
As the state has mentioned, they're alleging that insurance money was my motive. Social Security was my motive. Spouses having insurance policies is not a crime. Collecting Social Security is not a crime. Self-defense is not a crime. A family tragedy is not a crime. It's a tragedy.
Vallow Daybell's brother can't be charged in this case because he died in 2019 before charges were brought in court. Now, Vallow Daybell was already convicted in Idaho for murdering her children, Tylee and JJ, as you know. She was also convicted for her role in the death of her current husband's first wife, Tammy. Her husband, Chad Daybell, was also convicted in Idaho for charges of murdering Lori's children and his first wife. He was sentenced to death in that state. All right, now joining us, we're lucky to have today Bonneville County Prosecutor Randy Neal. Now, Randy, you've been kind of following these cases as they go along, and it's been pretty interesting to watch this one, quite a bit different than the one that we saw in Idaho, where we didn't hear anything from her at all until her sentencing. This time, she's representing herself. What does that mean for the jury, for the prosecution, and for the defense?
Well, I mean, the conventional wisdom is to, have a separated lawyer helping and represent you. Most lawyers would not represent themselves just because you're too connected to the case. But there's a double-edged sword there because a layperson is actually talking to a group of lay people. So they can actually connect in ways that sometimes get lost in the legalese of lawyers. So it'll be interesting to see how they react to it.
Mm-hmm.
We understand that the jurors themselves are going to be able to submit questions. Does that happen often? Have you ever been in that situation? And when it does, how's that handled?
Some jurisdictions allow it, and typically what they do is the judge receives a written question. It's not asked out loud, and then the judge decides whether or not it would violate the rules of evidence and whether the question would allow for some admissible response. Commonly, though, both sides are so thorough because they've got the interest in making sure all the facts come out that there's seldom a question that's left over. They're rare, and it's even more rare that the questions are allowed, but sometimes.
Yeah.
All right, so now this case, totally different than what we saw up here in Idaho. However, a lot of the moving pieces are the same. A lot of facts are already known because of the trials here about what's going on down there. How is that going to affect the way it proceeds in Arizona?
Well, typically, except for very limited circumstances, you have to keep the two trials completely separate, and only those facts that are relevant to the crimes down there. You can't try to get guilt by association. Typically, criminal records are not allowed in, and so her convictions normally wouldn't come in, with the exception of if she chooses to testify, they can use them for impeachment.
What are the chances you think she will testify in this case?
I don't have any better guess than anybody else. I wouldn't have guessed any of this would happen. It's a much different circumstance. I mean, she's got 3 life sentences consecutive, and so I don't know what she has to really lose down there.
Okay. All right. Thanks so much for joining us.
Thank you.
Good to have you on set with us.